Imagine sitting in a small interrogation room under the buzzing fluorescent lights. You're tired, scared, and just want to go home. The detective leans forward and says, "Look, your friend already told us everything. If you just confess now, it'll go easier for you." But what if I told you that could be a complete lie? Welcome back to Due Process Daily. Today, we're breaking down a question that shocks almost everyone who hears the answer. Can police legally lie to you during an interrogation? The short answer is yes. In the United States, police are allowed to use deception as a tool during questioning. But let's unpack that, because the implications are deeper than most people realize. This practice is called strategic deception, and it has roots in law enforcement training nationwide. The general idea is that by lying about certain facts, police can pressure a suspect into confessing or revealing information they otherwise wouldn't share. But is that ethical? Is it even constitutional? Let's take a look at the legal backdrop. One of the foundational cases here is Frazier vs. Cupp, decided by the Supreme Court in 1969. In this case, police falsely told the suspect that his cousin had already confessed. The suspect then gave a partial confession, which he later tried to suppress, arguing that the lie coerced him. The Supreme Court ruled that the confession was admissible. They said deception is only one factor in determining whether a confession is voluntary or coerced. The court explained that if the lie doesn't overbear the suspect's will or produce an involuntary confession, it doesn't violate the Constitution. This means that while police deception is scrutinized, it's not automatically unconstitutional. Another famous example involves the Central Park 5 case from 1989. 5 teenagers were interrogated for hours without food, water, or sleep. Police lied to them, saying the others had already implicated them, and promised they could go home if they just confessed. Each of them gave false confessions, and they were convicted. Years later, DNA evidence proved they were innocent, and the real attacker confessed. This case sparked outrage because it showed how powerful and damaging police deception can be, especially when used on vulnerable suspects like juveniles. It also shows how lies, coupled with coercive tactics like lengthy interrogation and isolation, can lead to wrongful convictions. Now, legally, what are the limits? The Supreme Court and lower courts have set some boundaries. For example, police cannot fabricate physical evidence. Imagine an officer bringing in a fake lab report claiming your fingerprints are on the murder weapon when they're not. Courts have generally ruled that creating fake documents or evidence crosses the line into coercion, making any resulting confession inadmissible. But lying about what someone else said, that's usually allowed. Lying about having eyewitnesses, usually allowed. Lying about the severity of the crime or the possible sentence, often allowed. The line is crossed when the lie is so extreme or combined with other coercive tactics that it overcomes a suspect's free will. One notable case highlighting these boundaries is People vs. Mays in Illinois. Police told a suspect that if he didn't confess, he could get the death penalty, but if he confessed, he would only get probation. That was a lie, and threatening someone with execution if they don't confess is inherently coercive. Another example is Linneman vs. Illinois, a 1963 Supreme Court case, where police threatened a mother that if she didn't confess to selling drugs, she would lose custody of her children and her state financial aid would be cut off. Court ruled her confession was coerced and inadmissible because the threats overbore her will. So what does this mean for you if you ever find yourself being questioned by police? Just understand that the person sitting across from you is allowed to lie. They might say they have video evidence when they don't. They might claim your friend implicated you even if your friend never spoke to them. They can even tell you that confessing will help you, when in reality, it could seal your fate. This is why one of your most powerful rights is the right to remain silent. Under the Fifth Amendment, you don't have to say anything that could incriminate you. And under Miranda v. Arizona, police are required to inform you of that right before a custodial interrogation. Remember, you have the right to remain silent. Anything you say can and will be used against you in a court of law. But here's a crucial nuance. If you start talking, even after being read your rights, and you don't clearly invoke your right to remain silent or your right to an attorney, police can continue questioning you. You have to say something like, "I want to remain silent," or "I want a lawyer," for them to legally be required to stop questioning. In fact, the Supreme Court in Berghuis v. Tompkins ruled in 2010 that simply remaining silent isn't enough to invoke your rights. You must clearly state it. In that case, a suspect sat silently for nearly 3 hours of interrogation. Eventually, the officer asked him if he believed in God and if he prayed for forgiveness for shooting the victim. The suspect said yes, and his statement was used to convict him. The court ruled that because he hadn't clearly invoked his right to remain silent, his eventual statement was admissible. These cases highlight how important it is to understand your rights and how they actually work in practice, not just how they're portrayed on TV. Police are trained to build rapport, to isolate, to use time and pressure as tools. When you combine those tactics with strategic deception, it can become a powerful psychological weapon. Another famous case demonstrating the dangers of lying interrogations is the Norfolk 4. In 1997, 4 Navy sailors were accused of raping and murdering a woman in Norfolk, Virginia. Police told each sailor that the others had already confessed and implicated them. Faced with these lies and lengthy interrogations, each sailor confessed to a crime they didn't commit. Years later, DNA evidence linked another man to the crime, and all 4 were exonerated. So what can you do if you're ever in this situation? First, remain calm. Second, don't try to outsmart the police. Remember, they are allowed to lie, but you are allowed to remain silent. Ask for a lawyer and stop talking until your lawyer is present. Once you ask for an attorney, they must stop questioning you until your attorney arrives. Some states are now rethinking these practices. For example, Illinois and Oregon recently passed laws banning police from lying to minors during interrogations. Lawmakers recognized that juveniles are particularly vulnerable to deceptive tactics, often leading to false confessions. Advocates are pushing for these protections to be extended to adults as well, but as of today, strategic deception remains a legal and common tool in American policing. Ultimately, the takeaway is clear. Police deception during interrogation is legal within certain boundaries. The courts have ruled that while lying is allowed, confessions must still be voluntary. But as history shows, the line between voluntary and coerced isn't always clear. Famous wrongful conviction cases demonstrate how lies can distort reality, destroy lives, and undermine the very purpose of justice. That's why knowing your rights isn't just about reading them off a Miranda card. It's about understanding how the system works and protecting yourself within it. Always remember, if you are questioned by police, you have the right to remain silent. You have the right to an attorney. Use those rights. Thanks for joining me today on Due Process Daily. If you found today's discussion enlightening, make sure you subscribe to the channel and hit that notification bell so you never miss a breakdown of your legal rights and the truth behind the headlines. Drop a comment below sharing your thoughts on police deception. And if you want to see more real-world legal breakdowns, let me know. Stay informed, stay empowered, and I'll see you in the next one.